First speaker is Mehak Kawatra. She's a graduate from U of T Law, and before she completed her JD, she obtained her Bachelor's of Art with honors from the University of Toronto, majoring in English and criminology. She worked for the Human Rights Watch and U of T Law's International Human Rights Program. Today, she'll be telling you more about narrative and law. And please keep your questions to the end because there'll be a Q&A session. So let's give Mehak a warm welcome. Mehak?
Hi, everyone. Thank you for that introduction. Firstly, I just want to start off the day by congratulating future lawyers on hosting their very first conference. This is, I think, really important because access to justice on some level just really begins with access to opportunity, specifically an early opportunity to sort of explore the legal career and, how it works. So this is pretty freaking cool. So thank you for hosting this. And also, thank you for inviting me as your keynote speaker today. It's a special honor to be asked to speak to an audience comprised of, young, eager, and bright minds like yourselves. And my hope is that by the end of the talk, you will gain a perspective into the study and practice of law that is somewhere in between technical and academic, but hopefully productive and very valuable. Okay, so who am I and why am I here? So I know that I was just given that introduction, but I thought I'd say a little bit about myself so you have that perspective. My name is Mehak Kawatra, and I graduated from the University of Toronto Faculty of Law, class of 2020. In other words, I literally graduated 3 months ago. I'm not a lawyer yet. So in my undergraduate studies, I was involved with a lot of research into sexual violence against students on campus, specifically undergraduate campuses. And that inspired me to look into women's rights law and human rights advocacy. And so in keeping with those interests, in my second year of law school, or just before I went into my second year of law school, I interned with the Women's Rights Division at Human Rights Watch. Shortly after returning back to law school, I worked for the International Human Rights Program, also at U of T Law, with their Rwanda Genocide project. And actually that is how I encountered the hosts of this organization when I was giving a talk and presenting on the Rwanda Genocide project. I will promise to return to this topic later on in my presentation today. I'm now actually currently working at a private full-service law firm in Toronto, Bennett Jones LLP. And I'm happy to talk about that in the Q&A session if that's something that interests you. It will not, unfortunately, be something that I will talk about in my speech. Okay, so when I applied to law school, I wrote my personal statement focusing on the theme of voice. This is a somewhat cliche idea, the idea that I want to be a lawyer because I want to use my voice to assist others. This kind of sounds very familiar and very conventional. But little did I know that, this very relatively simple concept of voice would have such weight 3 years later and actually has become, for me, the most effective way of viewing law, advocacy, and how to effectively represent clients. This concept of voice. So I thought for my talk today, I'd like to focus on the power of narratives and its relationship with law. Now, here's what to expect, right? So I will define the term narrative for you and proceed to persuade you of its inextricable relationship with legal research and legal advocacy, specifically in the realm of human rights, and in the context of litigation and dispute resolution, where I think it is truly the most effective. So my goal in discussing law and advocacy from the lens of narratives is to ground your perspective about the study of law, the practice of law, how it works, and what to expect. So you've got a huge lineup of very qualified legal professionals who are going to tell you a great deal about corporate law, criminal law, and the day-to-day practice of law, and that's absolutely wonderful. But at this stage, when you are, exploring your options, I think that there needs to be a higher level organizational theory that you can kind of return to ground all of this information you're about to receive. So my goal for me really is to persuade you that this higher level organizational tool is the tool of narrative. Okay, so I'm about to share my screen with you and hopefully that works effectively. Okay, Does that work? Can someone give me a thumbs up?
Yep, it's good.
Okay, excellent. Okay, so it may come as no surprise to you that I majored in English literature. That was said in the introduction, but truly it's going to come, kind of very obvious now that I studied English literature in my undergraduate studies in my pre-law life. Now, what's interesting is one of the first things that we learned when, we start off, or one of the first things all students learn when they start off in English literature, is the distinction between stories and narratives. A story is the plot, right? It involves the unfolding of events as between key characters. It is the objective progression of events. This is your, exposition, rising action, conflict, climax, falling action, resolution, right? We love stories, and we have a real way of viewing the world and its people and its, very long, complex stories. Narratives, on the other hand, are about storytelling. It's about how the story is told, or about how we tell the story. It's less about what is happening, actually, and more about how you present the tale. So importantly, the narrator is always motivated to tell the story. And the corollary to this truth is that the narrator will always have her biases. Indeed, the most fun I've ever had as an English literature student was in deciding what the narrator's motivations are and kind of pulling them apart to figure out whether or not she gets to tell the story. And this distinction, for our purposes, is the key distinction for law, the difference between the story, the events as they happen, and then how the story is told, the narrative voice. So there is the objective reality of what has happened, and the facts, as we call it, and the key players who set the events in motion. This is your plaintiff, defendant, the accused person, in some cases the victim, if the victim, chooses to present. But distinct from what has happened is how the facts are communicated. The voice of the story holds all of the power. This is a complex and layered process. Well, for one thing, you have the client's voice. This is the client who shares the facts, the events, as we're going to call it. The client whose interests are at stake, and the client who is seeking a very specific resolution of sorts, right? This is going to be either a transaction or a dispute, but the client has her own motivations. And these motivations will forcefully operate to challenge the other possible voices that are vying to tell the story. But then you also have the law's voice, right? This is the legislation that's passed by the appropriate government body. And in common law jurisdictions, this will include the court's final authoritative voice. Importantly, there's always going to be a legal narrator who interprets the facts. The narrative voice that speaks neutrally does not point fingers, at least it doesn't seem to point fingers, but it is capable of viewing facts in a very specific and particular way. So why am I telling you about this? Because this is essentially the sphere of law, right? Operating both in between the law's narrative voice and the client's narrative voice is the lawyer, but kind of operating above both of those voices is also the lawyer. As between these voices, the lawyer's role is to reconcile the client's narration and the client's motivations with the legal narrator's capacity to make sense of the story. This is the court. This is the actual legislation. The effect of this reconciliation of sorts is in the blending of these two narrative voices. And thus, the lawyer operates in some ways above the client's voice and the legal voice. The interrelationship between these three key players it will culminate in the expansion of common law. And this is what allows the law to grow, make room for new stories, new events, different facts, different interests. And this is how lawyers help to set precedent. I'm hoping that this is not entirely bizarre to you at this point, but let me go a step further to make this more concrete for you. Let's talk about legal research. I've chosen litigation here because my own personal interests are in litigation, but you can consider both transactional work and dispute resolution. So let's actually talk about the transaction super quick. The transaction is easy. right? This is the client's narrative on how to get the deal done. The client has her own interests in wanting this transaction to be completed. And the law's narrative is relatively simple. It's regulatory. The law is just going to tell the people how to be compliant and what steps need to be taken in order to get the deal done. Sorry about that noise, guys. So the lawyer's voice in this transactional scenario is really just going to draft that contract so the deal is legally compliant and also at the same time protecting her client's interests. But the dispute, the conflict situation is what I'm more interested in because it's trickier and not just because I'm biased. It's just more fun to play with it. So the legal research here, when we talk about litigation being when you take the dispute to court or when you sort of decide the dispute in front of an adjudicator or an arbitrator of sorts who has that binding voice. So here, this is, you have the client's story, you have the facts. Who are the major players? Who has created the conflict? Who has the interest in the tension? What rights or interests are being threatened or downright violated? The legal research here is into the law, right? That's what we have here. The legal research is into the law. It is into, the anticipated facts, whether these scenarios have occurred before, whether there is relevant legislation. And really, the question is, what has Lady Justice said about these facts in the past? This is, of course, going to be your memorandum of law that the lawyer will draft. This is going to culminate in the argument of law, as we call it. Finally, these submissions that are made to the decision maker is the lawyer's narrative, right? These are the submissions made to the court, and it's going to include the lawyer's story of what has happened. She will persuade the court or adjudicator to interpret the story in the way that she's portraying it, which for any good lawyer is going to be in the client's best interests. She will use the legal narrator's own logic, the law's own logic in previous case law to make this happen. When the decision comes out finally, deciding the client's specific story, the facts, the salient facts, the lawyer has contributed to the development of the common law by challenging or clarifying its limits. She has set precedent in so doing. I hope you're with me so far, but this is essentially how legal research works, and it's going to be a great deal of what you do in law school, and it's going to be a great deal if you decide to go into litigation. It's going to comprise a great deal of your practice as well. So I'm hoping that this is fairly straightforward, but I'm about to complicate the paradigm a little bit because that's just truly, honestly, more fun. So up until this point, I've tried to draw a parallel between narratives and legal process, but the narrative is actually not just a procedural analog to law and how it works, right? Narratives have their own intentional role when we talk about advocacy, and specifically justice for victims of human rights violations. Sometimes the fairest way of bringing justice is in the very act of telling the story to a global interested audience who actually wants to learn about the events as they are being told, specifically as they are being told. This is an audience with the power to acknowledge, validate, and respond to the atrocities committed. And now I'm thinking specifically about my work with the Human Rights Project or the Human Rights Program at U of T Law related to the Rwandan Genocide. Okay. So let's just talk briefly about the Rwandan Genocide before I get into the power of narrative, which I find so very compelling. So the world will remember the Rwandan Genocide as if it happened yesterday, and rightly so, not only because it happened so, in the recent past, so, fairly recently, but because of its lasting impact. This episode sticks out in international memory because of its widespread use of sexual violence and rape against the Tutsi population, against the ethnic group targeted here. And it was the primary means of eliminating the group. It wasn't just violent bloodshed and killing and massacre, it was rape and sexual violence. This is to say that people did not just die, people were violated and infected and left to spiritually and mentally rot for the rest of their lives. They're not dead, they're alive, and they can talk. And we are interested in hearing their stories. The genocide lasted for 100 days between April 1994 and July 1994. And between 250,000 to 500,000 women and men were raped, right? Grandmothers were raped in front of their family members, in front of their children. Little girls were raped, and little boys were made to penetrate Hutu women. So, as a result, there are survivors who live with sexual diseases of sorts and with very vivid memories of what has happened. Survivors live on, coexisting with their Hutu neighbors. Rwanda today, it's a community of coexistence. There are survivors who live next to the perpetrators who killed their parents, who raped them, whose children go to school with their own children. Rwanda today lives as if the Rwandan genocide has not happened for everyone but the Tutsis, who cannot forget that it happened. So in 2019, the International Human Rights Program, the IHRP, team at U of T Law, in collaboration with a few Dutch researchers who specialize in sexual violence as well, we published this book, and I have it here. I'm just going to pull it up if you're looking at the screen. I don't know if you are. It's called And I Live On, and actually the front here, the cover, you can see one of the survivors, Marie-Louise, and she absolutely, she has one of the more powerful stories in the book. So in this book, 17 survivors share their own stories of genocide, translated into English. The book is a sequel to the 2008 edition, in which the survivors shared their stories of grief and trauma. But more than 10 years later, right in 2019, the book specifically captures the survivors' stories of growth and healing. And the interesting piece about these narratives is that there is no adjudicator, there is no court, and there is no one specifically deciding the outcome of these stories. There is no real law that is also motivated to tell the story. The international law has the genocide, the body of international law on genocide sets the rules, but largely its enforcement is a very domestic sovereign problem, and there is no law really that is motivated to tell these stories. But these voices live on, right? They are live people, as I've said before. These voices live on, they share the tales, forcing the international community to acknowledge, remember, and help rebuild what was almost entirely demolished. This, for me, is the ultimate power of narrative in and of itself. It is the very act of telling the story to an audience that can serve as the appropriate remedy in just being there as the audience. It happens that every sale of this book raises funds for the survivors on the ground, and that money does more for them than any court of justice can after all of the violence that has happened. I'd like to read to you very short quotes from two of the survivors about the power of narrative. So Marie-Louise tells us that, "I hope that my story will help others understand what happened in Rwanda, and I hope that it helps other survivors through the proceeds of this book. Although we lost so many people we loved, we need to continue to hold each other and stay together." Olive tells us, "I have shared my testimony here so that the world may know what really happened in Rwanda. So much pain still lives inside of us, and the fact that most of us live with HIV makes things worse. I live in poor conditions, and I do not have the money to pay for my children's school fees. I wonder what will happen to my children when I am dead. I hope people will reach out to help them. I pray that the truth about the genocide will one day be revealed. Genocide is a vicious cycle. I hope the world ensures that genocide never happens again, because I want a bright future for my children, and I never want them to endure what I have." These two excerpts, I'm hoping, will show you just the power of telling the story. In fact, in international human rights law, we have the concept of transitional justice. This is locally, in every sovereign country that has experienced human rights violations on a mass scale genocide, there are these local tribunals, these courts, these community courts that are set up, comprised of the victim population or representatives from the victim population, who then decide to punish certain perpetrators who get selected and sent to these courts to be tried. In Rwanda, these are called Gacaca courts. And there, the entire premise of the Gacaca courts is to have the victim, is to have the survivor share her story, his story, about what has happened. And it's the power of the narrative that then unfolds and sort of allows for that healing process, that confrontation process to happen between the victim and the perpetrator before that punitive process sort of unfolds thereafter. So this is the power of narration, right? Human rights is about narrative. And I want to stop sharing the screen, so I'm going to do that now. Okay, great. So this for me has been the power of narrative, and it serves, I think it serves a compelling perspective for legal process, but also as a powerful tool for advocacy, specifically human rights advocacy. My hope is that by the end of this talk, you've gained a higher level, again, that high level perspective of understanding when it comes to legal work, its content, its purpose, and its overall effectiveness. That's all I have to say. Thank you for listening, and I'm very happy to have this perspective challenged or to talk about it more in the Q&A section. Thank you.
All right, thank you. All right, thank you. So we're gonna start the Q&A part of this call. So send your questions to the chat and please be respectful. We'll be reading the comments. So if you have any questions, please ask them.
All right, maybe Mehak, you can maybe give a little bit about your experience in law school before we continue with the Q&A session.
Oh, sorry, I was muted. I think we actually got a question, but I will be happy to answer about my experience in law school. I think that's a really broad question, and I would encourage people who have very specific questions about law school to ask them. But I think law school is a lot of the legal research component that I try to cover in the presentation. It's a lot of reading previous cases and sort of playing with the logic of the law to figure out how new facts or related facts can sort of fit into the legal landscape. It's a lot about changing the way you think, changing the way you process, in some ways, the world. And it's about how you can be creative with your analysis and your solutions. So law school is about professors sort of very academically teaching you these things, and then all of the experiences that you have outside of law school but are law related are about how you can actually practically use that new way of thinking to then help either a client, a company, a corporation, or whatever cause that you're involved with.
Okay, so we'll go to our first question. It's from Sarah, I think. Mm-hmm. Yeah. How did you get into international human rights law? And specifically, how did you find work in that sector?
Yeah, so I got into human rights. So I chose University of Toronto Faculty of Law because of their international human rights program. That was a huge, huge, huge part of the reason why I chose that school to begin with. When I wanted to go to law school, again, I had that sexual violence background. And for me, you know, I wasn't sure specifically about what I wanted to do at that stage, but I knew that I wanted to explore the avenue of human rights advocacy. So the IHRP was that blessing in disguise. It wasn't really even in disguise, but it was that blessing for me. And so I networked with the director of the program literally the second day of law school. And I said, hey, I'm really interested in what the IHRP does, and it's my dream to be, you know, involved in some capacity. Please let me do that. And then I started off relatively small in like working groups, just sort of looking at immigration refugee cases in Canada, so not international, but it was just contributing to a bulletin to help the federal government sort of appreciate, you know, its trends in decision-making and tribunal decision-making when it comes to immigration and refugee claims. And then thereafter, I applied to be, you know, involved in one of their selected projects, which included the Women's Rights Division at Human Rights Watch. I got selected. I went to Washington, D.C. for 3 months. I worked for the Human Rights Watch there under incredible international lawyers, did some really awesome work, mainly in legal research. And then I went on to come back to do some work for the Rwanda Genocide project, which I just described.
All right. Tana says, could you expand on using narrative elements when legal researching? So how does narrative elements impact how we find the truth?
So truth is relative, isn't it? And that's kind of the point, that truth is whatever you want to tell someone the truth is, right? There is going to always be some objective fact that you can't deny no matter how hard you try. And there's always going to be the evidence, and the evidence has its confines, and the evidence will speak truths of their own, right? There is no court of justice that, you know, you can point to something that's black and say it's white when it's very clearly black. But fortunately for lawyers, things are rarely ever black and white, right? And so the truth finding process is really how the facts interact with the law. Sometimes as lawyers, you have really bad facts, right? And your client is motivated to get the cost effective or to get the very vindictive resolution that, you know, she wants. And, you know, you're going to have to deal with those bad facts. And the best thing that you can do is turn to the legal narrator, turn to the law, turn to the court, look at previous cases, research the facts as if there is no tomorrow, look at every single instance where all of the important facts have happened. And you're going to say, look, I know that this is the fact and this is how it's played out in ABC cases, but this fact that you think is really bad has played out in an entirely different and actually beneficial manner in XYZ cases. And this is what I want you to look at instead. And that's going to be the lawyer's narrative voice, right? Just sort of portraying the story, the facts, the salient facts in the way that actually serves the client's purpose. And the truth finding process is kind of what happens at the end when the court says, okay, so I've seen this one fact play out in ABC context in this way, and then I've seen this one fact play out in XYZ context in this other way. So what is the truth of this fact? So when it happens again, what's the court supposed to do? Is that you can't have one or you can't have both kind of coexist unless there's some way to sort of make it all make sense, to reconcile all of the realities, so that this fact can then accommodate for A, B, C, X, Y, Z. Hopefully that wasn't too abstract. If it was, let me know. I can clarify. But the truth finding process and culmination is really something that is super relative, and it's going to depend very much on the strength of the advocacy and also the strength of your research, right? Just sort of making sure that you've covered all of your bases and all of the facts have appeared in the cases, and you know those cases so that you can play with that logic and be extremely creative.
Okay, so another question from another attendee is, what is the toughest case you've worked on and what was the outcome?
I am not a lawyer, so I have not worked on any case. And I have not actually yet had a chance to see the case from beginning to end. I'm going to do that now because I'm an articling student, and now, you know, you're actually on a file and you get to see it from literally beginning to end. Usually my role has been to do all of the research and then to prepare the memorandum of law and to help maybe perhaps write the submissions to the court. Or it's been at the tail end where, you know, all of the research has been done and I get to go to court and I get to assist the lawyer, you know, having looked at the documents, having been briefed on it, to sort of like be that person to like assist with pulling out documents and just to watch the submissions being made. I've made submissions in school for competitive purposes, for training purposes, but definitely not a lawyer, definitely not worked on an interesting file from beginning to end that I think I could validly comment on that could actually add any value. So I'm not going to do that just yet. Sorry. Ask me in 2 years.
Hold on, I'm just looking for some questions. Okay, so Sophie asks, would you recommend doing internships or volunteering during school? And do you have any specific organizations that you may recommend?
Yeah, I think you should do both, right? So I did both. I interned in the summer between summer between first year and second year of law school. So it wasn't like a thing that I was doing that interrupted my studies. And that was cool because I got to have a summer away and I got to do something that, you know, I really enjoyed. And then I also volunteered a lot. So I volunteered for a women's rights clinic Really, it's a domestic violence anti-abuse clinic called the Barbara Schleifer Commemorative Clinic. It's Toronto-based. It basically helps women who have been abused, who are victims of violence, sort of who have family custody kind of issues as well, not just the criminal components, seek legal assistance, but kind of holistic care, social work assistance, therapy, healing groups, sort of recover from that trauma, seek a safe space, make sure that, you know, they have emergency contacts, that they don't feel like they have to go home to their abuser. And also the clinic assists them with legal advice and, you know, just sort of accessing free, as in subsidized, legal advocacy for their family and pseudo-criminal matters. So I worked for that clinic I first worked for that clinic as a volunteer, just sort of working there was almost no legal work involved there. I was just with the clients, with the women, you know, once a week for 4 or 5 hours. I would just hold their hand, listen to their stories. Aha, stories again, sorry. I just love this concept of stories. But see, you would listen to their stories and you would let them heal by sharing, and you would kind of be there and sort of reassure them that at least they, you know, in being with you, are in a safe space when they're not really sure what their safe space kind of looks like. And then I went back to that organization again as an extern student and kind of did a little bit more work in terms of just being with the women, but also kind of interviewing them so that we could take down all of their facts, all of the events, and sort of relay them onto the social workers, the legal workers. So I did that. And I did a couple other things. I worked for like 3-4 months, worked is a loose term. I volunteered for the Advocacy Centre of Tenants Ontario at the Landlord Tenant Board Tribunal, just to sort of assist with clients who were coming in, or just people who were coming in with primarily tenant issues, but their landlord abuse issues, and coming in, you know, seeking counsel advice on how to deal with something that's either administrative or something like, you know, that's pretty fundamentally discriminatory or, you know, housing crisis related. And then I in my final year, when I, you know, achieved some level of sophistication, I would suppose, with the law, just sort of I kind of knew what was going on a little bit more, because it's a work in progress. I volunteered with the Pro Bono Ontario organization in Ontario, but their Toronto courthouse office at 393 University, which is in the core of downtown Toronto. And there you sort of assist, you triage, you assist people who walk in who are self-help, they're self-help litigants. They don't have lawyers, but they need legal advice that they can go and make their submissions themselves. So they walk in, they're either plaintiffs or defendants in, you know, private matters, civil court matters, and they just want 30 minutes of a lawyer looking at their documents, a lawyer looking at their facts, a lawyer just providing, you know, some kind of advice about the strength of their case, or even like editing their documents just to be like, okay, you're good to go. These are your timelines, make sure you adhere to them. And then as my job in that capacity was the most kind of rewarding, where I got to meet the clients first and I got to take all of their facts and sort of note up for the lawyer, this is their case and this is the most important fact. And I think for, you know, obviously as a student, you can only just think, you can't decide, but I think that the case is going to be about this, and this is the nature of the advice they're seeking. And then you kind of get to like sit in, you check in with the lawyer, and then you kind of like, basically it's was I correct in analyzing that this is the client's problem and this is how to proceed, or was I horribly wrong? And I did that for a year and I learned so much. So that was a very long story, but I said it in part because everyone, I'm sure, is interested in the things to get involved with in law school, and really do what makes you happy, but get involved. Volunteer, do externships, do internships, and sort of just don't be afraid to experiment and go out there and speak your mind, even if you're going to be wrong. Just be humble, you know, just accept the fact that when you open your mouth, you might say something egregiously wrong, and, you know, be the first person to accept that. And otherwise, I think you have to go out there and you have to experiment and try. Otherwise, you're just never going to know. And then you're going to probably regret it later. So that's my word. Those are my words of advice.
Okay, so we have another question. Did you know that you wanted to go into human rights during high school, or was it a decision you made during your undergraduate degree?
Well, so I'm not in human rights right now, so I don't even know if it was a decision per se. So in high school, I always knew I wanted to go into law. I just hadn't quite decided where my heart kind of lies in the law. You also don't really know a lot of things when you're 16, 17, you just kind of have vague ideas. But I'm Indian, and, you know, I used to hear so much about the rape crisis in India. And I have the privilege of being in Canada. I'm not actually living in India, so it doesn't affect me directly, but I have family members who live there. And, you know, I was always interested in following up and, you know, learning about the atrocities and also just the gang rape, the mass violence against women, and just the general environment that, you know, was lack of safety for women in India, specifically in Delhi. And I was always interested in women's rights as a result of that. I think it just kind of came naturally when I did sexual violence work. I took a genocide course in undergrad, and I, you know, happened to connect really well with my professor. And actually I would advise that too, that, you know, it's not just about law school, it's about making connections in undergrad and, you know, being very assertive with what you like and what you want to explore, and reaching out to professors who do that kind of work, even if it's in an academic context, right? Which is what most of university is. It's not really professors going out and advising anyone to do anything really. It's just about their own research. But I actually took a genocide course, and then, you know, the professor who taught it was piloting the sexual violence project of basically measuring the incidence of sexual violence primarily against women on campus, but also just the general nature of research around sexual violence studies. And then it just kind of came naturally. Like I ended up having built pseudo expertise in sexual violence, so that when I went into the human rights program at U of T Law and I spoke to the director, like I was already pinned as the person who would do the women's rights work, right? Because there were lots of LGBTQ activism that was happening. There was also like immigration and housing crises, food crises. Like human rights is really broad, but I kind of ended up self-selecting, but also getting selected for the women's rights stuff.
Lena asks, is there any mental or psychological toll you endured during your pro bono volunteer work?
So yes, of course. This is going to sound really weird, and I'm not tooting my horn, I promise, but I actually think that, so I spoke on this in a podcast for the Rwanda Genocide Project, because when you read the stories of the survivors, they're graphic. They're a lot, right? And you can't just read them anywhere. I remember trying to read them on a subway once, because I had to, you know, brief myself really quickly on some of the narratives before our first meeting. And I just burst into tears, because it was like so morbid, and I had no concept that was coming, you know, and I didn't realize that it would be that graphic. So, and it was like bursting into tears out of panic, not like deep emotional sadness, although that is obviously there. It was more just like, this is so vivid, you know? And if you are someone who has like, you know, you are someone who's empathetic, or not just, that sounds kind of terrible, but like you are someone who connects very easily and very deeply with other people's stories. And I am someone who's like that, you know, it can take a toll on you. And when I was working for the Barbara Schleifer Clinic, you know, it was heavy stuff, and you do carry it with you. But in the podcast, which I can't even remember what it's called, but it's a U of T podcast. It's actually about how to cope with, it's in part about how to cope with, you know, the mental and psychological toll that human rights advocacy can take on someone who, you know, doesn't really, like, I'm still a student, and I didn't receive any special training per se in how to do this kind of emotional work, but it is a lot of emotional labor. And I think the best thing that I can say is that if you are motivated to do the kind of work that, you know, does entail this mental, psychological toll, just make sure that you have personal supports, and that you have people who are working on the project that you can confide in and have a conversation with. And just try your best to compartmentalize. And, you know, when you're there, it's okay to be immersed. It's okay to hold her hand. Like, I was very happy to hold, to hug, to hold the women who came into the clinic, and to give them that physical comfort. But, you know, make sure that when you're doing that, you set boundaries for yourself, so you're not taking that stuff home. You're not taking that stuff to sleep at night, so you don't dream about it. You know, you just have to put in extra labor, unfortunately, at least until it becomes easy.
Okay, so we have about 5 minutes left, so we'll maybe take on one or two more questions. So we have a question from Brandon, and he says, when dealing with non-litigation stories, for example, the Rwandan genocide story, how do you ensure that the narrative of the clients is fair in legal sense or narrative, especially when there's no legal body dealing with the issue?
I actually weirdly think that that is the most fair it can be, right? So let me tell you what I mean by that. When you have the client's voice and you have to, as a lawyer, you have to work so hard to make the client's voice fit this legal voice, because that's the voice that matters. That's the voice that's gonna, decide. You're actually, I think, on some level, you're doing the client injustice, right? Because you have to tailor it, you have to kind of mess with it, you have to kind of usurp the client and be the client's voice. That's the advocacy piece, right? But I think in the non-litigation human rights context, perhaps the only benefit of the transitional court system really is that the most fair it can be is having the person who was violated, who has that kind of trauma, who, is suffering, to tell their story in the way that they want to. And nobody gets to deny it, right? Because there is nobody deciding that, oh, you didn't really experience that. In an ordinary court of law, when it comes to litigation, you have to prove the facts. They don't just exist, right? That's what evidence is for. You have to say that this happened and here are the receipts for it, right? I'm being a little crass about it, but the point is that there's always going to be evidence. You don't just get to accept facts out of thin air. You don't just get to deny facts out of thin air. But in the non-litigation human rights context, when everybody acknowledges that there was a genocide, and that is the premise for the communal courts, the client's story is the client's story. No, there is no lawyer who's telling it on her behalf or on his behalf. And there is nobody who's going to correct the person. And it is the fairest way of telling the story, I think, is just to let the person who experienced it, who has her or his motivations, to just tell the story. I can see that you answered, Brandon. You're welcome.
Okay, so I think we can answer one more question. So Nina asked, what do you think lawyers could do better when it comes to women's violence cases?
Wow. I don't know if I would say what lawyers could do better, because I think it's really what the law allows the lawyers to do. I think the law just needs to be a little bit better. And by a little bit, I mean a lot better. There's a lot of, I have 2 minutes, so I unfortunately cannot get into the thick of, honestly, it's very complex. The law has largely in presentation shown a lot of willingness to accept violence against women. So we have battered women syndrome that has now been accepted, as like a self-defense, mechanism for under criminal law. So, for example, previously, in order for the doctrine of self-defense to apply, you needed to have the trigger, you needed to have that provocation, or like the doctrine of provocation to apply, you needed to actually have that immediate threat for you to be able to justify what you did as, self-defense, that I was literally going to die and this is the only option I had, right? But with battered women syndrome, you're always kind of feeling under threat, and maybe the immediate trigger wasn't warranted or did not warrant the violence that came out of it in an ordinary circumstance. But the court now recognizes that battered women syndrome is a thing, and that for women, how they perceive it, especially if they've been victims of abuse, for them, it takes that trigger is sufficient if you can prove that they are battered women. So to answer the question specifically, I don't know what lawyers can do better, but I think that there are ways in which the law has still to cope. Like, that is one example in which the law has progressed, but there are a lot of other confusing ways when it comes to sexual assault, how complainants can be portrayed. That stuff is still I think, being worked out. And there's a lot more, I think, even from a political perspective, there's a lot more that the government can do in terms of investment and funding when it comes to assisting women who are victims of violence in kind of like the domestic violence context. I mean, we don't really have, we don't have the exact genocide sort of context here, although we have we have the genocide against Indigenous persons still in Canada with the Truth and Reconciliation reports, but I'm not certain that that's the point of the discussion. The point, I think, is more broadly that I think law should be, the law is still discovering its relationship when it comes to victims of violence, broadly speaking, specifically women. And I think lawyers can only do the job that they have if they have something to work with, and if they have the events that give rise to a new case, a new suit that can be filed, that can kind of force the law to push its limits a little bit more. But yeah, that's my answer.